Did you know that signing a notary deed in Cuenca doesn't actually make you a property owner? In fact, skipping one critical step could leave you with no legal rights to your new home, even after you've paid in full. Hey everyone, Jason here from YapaTree.com. We operate a real estate agency here in Cuenca, where my team and I help expats and locals navigate property purchases every single day, including the crucial steps of signing the deed and ensuring proper registration. Today, we're breaking down a topic that even seasoned investors sometimes get wrong: the differences between a notary deed and property registry in Ecuador. Joining me is attorney Sabrina Candela from Expat Law Group, a legal expert who's rescued numerous buyers from costly mistakes. Sabrina, let's start with the million-dollar question. When does a buyer truly become the owner here? And why is the property registration so non-negotiable?
Okay, well, hello Jason, and hello everybody. It's a real pleasure to be here with you again. Well, that is a very important question that we need to understand, because getting your deed at the notary, which is always the big step that you are, or that experts are always talking about, it's not actually what makes you a legal owner. What makes you a legal owner is to have that legal title registered and approved at the property registry. The property registry is the institution linked to the municipality that each canton of the country has, that has the registration and the listings of all properties and their owners. In the property registry, not only you have to register your sale and purchase agreement, but anything that deals or that has to be with real estate property, like a will with real estate property, posesión efectiva, which is part of the end-of-life documents that you get when you don't have a will, a donation of a real estate property, a sale of a real estate property, and it's non-negotiable, because if you do not get that registration, you will not be considered legal owner at all.
Sure, and in Cuenca, the property registration office, that's in the Primero de Mayo neighborhood.
That's on Primero de Mayo, right by the Reloj Floral.
Awesome. And just let's backtrack a tiny little bit with the basics. So can you just walk us through the standard property purchase process in Cuenca, step by step, and importantly, what should buyers expect from start to finish?
Okay, so let's imagine you already have your dream house. You have already chosen with your team, and you already know what property you want. So now you come to me to complete the legal process. The first part that we would do is we will have a meeting either with the buyer and seller or just with the buyer to discuss the conditions in which the purchase had been agreed on. Just things like, or details like the price, the date when it is going to be fulfilled, the date when you're receiving the actual keys of your property.
Is that two different dates, right? So you got the closing date, but then you've actually got the date where you may occupy the property.
Correct. Sometimes, and this is completely legal, sometimes the occupation date can be even before the actual sale. Sometimes it's after. Sometimes we have it to happen in the same day. Okay, so those days can be different, either before, after, or coincident. Okay, so we set those conditions. I prepare with a set of information that I would need, like the previous deed, the previous registration number of the property, the information of the seller and buyer, the information of the clave catastral, which is the code that identifies the property in the municipality, and the details of the transactions. I will be able to provide the minute, okay, which is the contract. Once we have the contract, we have to take it to the municipality so that they can calculate the alcabala, which is the purchasing taxes, and the plusvalía, which is the capital gain taxes that the seller has to pay. Then we pay the alcabala, we pay the plusvalía. We need to make sure that the property taxes of the year for that property has been paid already for the previous owner, because that is one of the documents that we need. And then once we have those plusvalía and alcabala taxes paid, we are ready to go to the notary. To the notary, we would provide the minute, which is the contract that I have drafted. Of course, in the process of drafting the contract, I always provide English and Spanish copies. We review it. If we need a separate payment agreement for the payment of the price, we can do it. So there are other details depending on the case, right?
Just on that, with the English and the Spanish variations, obviously it's important to note that only the Spanish version
will be the
one.
legal, exactly. Only, and I always clarify that. I always say, please find attached the two versions of the contract. The Spanish is for legal use, the English is for informative use, for yourself to read it and understand it. So we take this agreement to the notary. We also take the payment of the alcabala, the payment of the plusvalía, the payment of the property taxes of the year, of course, copies of the cedulas or passports of buyers and sellers. If anybody is acting through a power of attorney, the power of attorney, translated and apostilled if it's coming from a foreign country. And we also provide only for the cases of horizontal property, which are buildings, a certificate from the administrator saying that you are up to date on the HOA. With that, we can get the deed notarized and we pay the notary fees. And then the really important part comes, which is bringing this deed for the property registry for registration. Once that's registered, you are the owner, and we still have a few steps, which are changing the name of the property in the municipality for all that has to be with the municipality, like, very important, the property taxes every year, and then also Etapa for water, Centro Sur for electricity, internet if you want to keep the same service. And once all the changes of names are done, you're basically done with the whole process.
Awesome. That's super helpful going through that entire process. And so just coming back to the registration process a little bit here. So the exact role of the property registry, just walk me through that in a little bit more detail if you can.
Mm-hmm. The role of the property registry is to have the records of all the real estate property in the area, in the canton, and also have the records of the owners and the record of the legal transactions that were done with those properties. Okay, so in the legal framework, we have two different important concepts that are involved in any type of agreement. We have the title, which is the legal way in which you acquire a property, that in this case would be the title of sale and purchase agreement. And we have what it's called the modo, or the method, to use a similar word, which is how your title gets you the process of actually becoming the legal owner. Okay, in this case, it will be the tradición, or the tradition, which means moving a property from person A to person B. So at the notary, we get the title, the purchase and sale agreement. At the property registry, we get the method, the tradition between A and B to complete this new ownership.
Sure. And so, like, for example, if you're looking at an older house, that's something that's been around for, let's say, 100 years, that's going to have a lot of history attached to that particular property. And can you get access to all of that history attached to that property?
Yes, actually, this is not a step that it's necessary at the process of purchasing, but an extra value that my office provides is we can get the property records for your property in both the municipality and the property registry, assuring that you have that your property that you're willing to buy has no legal limitations, it's not involved in a trial, has no pending taxes, has no prohibitions for construction, and that it's, again, not a legal requirement, but it's this extra step that gives you security, and here at our office we can handle that.
It's the extra step of due diligence, and I know a lot of people don't actually take that step.
And it's really important because you can pay a full price, you can navigate the process that we have explained previously. We can get the deed at the notary, and then when we take it to the property registry, it doesn't get inscribed because, for example, it happens that this property, it's in the middle of a trial because the previous owner is in debt or bankruptcy or in the middle of an inheritance process, many things that can happen. So that due diligence, it's a real extra value that you want when you're purchasing. And those records you can get at the property registry for legal aspects and for taxation, limitations, permissions, so on at the municipality.
Awesome. And so let's say hypothetically, someone's bought a property, they've signed the notary deed, that's where the big sort of excitement happens. We're doing the signing, congratulations, all that sort of stuff. But then that's where the process stops. And so the question is, what sort of risks would that particular person be opening themselves up to?
By just getting the notary?
By just doing that part of the process, yes.
Well, the risk is you are not the legal owner. You have paid a full price, you have paid thousands in taxes, notary fees, and you remain with no real ownership.
So that title is obviously still with that previous owner, and they can effectively sell it again?
They could sell it again. Now, of course, I'm not saying that you will be left off with nothing, because the only right, you do not get ownership rights by just having the deed, if it's not described in the property registry, but you have the right, for example, to sue your seller to get back your money plus injury plus interest, depending on the case, if you cannot get it inscribed or if he sells it to a different person. So getting this notary deed does open many legal options for you, but not to become an owner, but to have to go fight in court house to either obligate the registration or get your money refunded. So it's not a pleasant process. It's better to avoid it. You do get rights again, but no ownership rights. You get the right of protection for this money you have paid.
So you effectively get the right to go to court and fight for ownership.
For ownership or a reimbursement of your money.
Sure.
Yes.
Awesome. So obviously that's not ideal. We want to try and avoid that, but at least you're not completely left in the dark with nothing.
Correct, exactly.
And so moving on to the property registration, the denials. So we do complete the closing process for some of our clients too, and it's quite common for little things to pop up in the process.
Correct.
And for the registration to be denied, which means that you need to fix whatever stamp was missing, whatever number was incorrect, whatever little thing that is basically some sort of issue that doesn't completely fit into the square box that they want. And so can you walk me through that process in terms of when something gets denied and how we can effectively fight to have that thing
completely registered? Yeah. Well, first of all, it's really important to understand that regardless of if you're dealing with real estate agents, attorneys, or even if you're doing this process yourself and you want to take that risk, it's not necessarily the fault of any of the parties involved to have a devolutiva, which is a rejection of the inscription. At the property registry, they're famous for, again, being really picky, even with things that are not even in the law. Just because they didn't like the wording, just because they didn't like something that doesn't really have any legal impact, but they still have the capacity to say, no, we're not registering it. It's important also to understand that we do have more, but majorly, and for the sake of practice, I will go over those two. Majorly, we have two principal rejections: devolutivas and aclaratorias. If you get a devolutiva, it's a tiny little thing like a name, they didn't like the way you wrote it, and basically what you do, and notaries will do this for you because they know how hard it is dealing with the property registry. You go back to your notary, or your attorney goes back to the notary. If you have friendship with the notary, it will be much easier. You go back, you show the devolutiva, you ask them for the changes that you want, and they will take off the pages that have the mistakes and replace them with the pages that match what they required. They staple the old ones on your folder, and then you bring that whole packet back to the property registry to get it inscribed.
Sure. And it's going to take another week, maybe two, and you'll get another answer.
Yes, exactly. It takes 5 business days for the property registry to give you a new answer for every time you go in with new.
That's best case scenario.
Sometimes legally 5 business days, but yes, sometimes it can be even 2 weeks, 2.5 weeks. Okay. Sometimes it's not only just a mistake on the papers, but a lack of a requirement. So you would need always to go back to the notary. For example, again, if it's a mistake on the writing, you go there, you ask them to correct it, and that's it. But if, for example, you lacked a document, like you lacked the payment of the property fees, for example, the property taxes, it's not just that you attach it and bring it back. You need to give it to the notary, so they put the seals, they do the new counting of the new number of pages and so on. So the notary will be always involved, okay? And then you bring it back and it will get registered. And it's not a tragic matter because, as you see, there is no money involved here. The notary will not charge you for doing this change, especially if your attorney has a good relationship with the notary. They will do it without any problem. But we have the second, that I call the monster, the aclaratoria. The aclaratoria comes when the property registry agent or officer thinks that you do have a major mistake in your legal contract. Because
what sort of mistakes are you talking about?
For example, you didn't include one person that had to be a party on the contract because you bought the property from a husband and a wife and the wife was not there. Or, for example, you had a purchase agreement, but you included a clause that it's only used for donation, for example. These kinds of mistakes that really alter the substance of your agreement, they will do an aclaratoria. And an aclaratoria you need to do at a notary. You need to produce a change on that original deed, and for that you do need to pay notary fees again. So you will have indeed extra expenses, and you need to pay for the property registry too. So that will cost you some money, and that's what you always want to avoid, getting an aclaratoria.
Sure. That's really helpful. So you got small mistakes and big mistakes. Big mistakes are going to cost you, ultimately.
Basically.
A little bit more at the notary. But in your experience, let's say we do have one of these issues that comes underneath the aclaratoria. How often would you say you're able to actually get that fixed and proceed with the transaction versus it's a really big issue, we have to walk away?
No, I will say if you get a good lawyer, 100% of the times you will be able to solve the problem. It will just cost you money, but you can solve the problems in 100% of the cases.
Sure. So that's our experience as well. We haven't really come across cases that we can't get past. We have come across cases that's been really tough. For example, when you got different family members involved and
Correct.
multiple family members, maybe they're on holiday, whatever. But
it can happen that to solve this problem, it's not as easy as going to the notary and getting the aclaratoria, but maybe if it gets to the point where, especially when we have a lack of a party that should be part, or the asset being in the middle of a trial or things like that, you probably have to pause the process and solve this issue at courthouse, and that will take you a while, but it's not walking away for good, at the end of the day. So yes, sometimes it's just a matter of going back to the notary, doing the aclaratoria, and you're done. You pay the fees. Yes, what a burden, but you can do it quickly. Sometimes we have to pause it, but at least in my experience, in none of the cases, if you get a knowledgeable legal advisor or attorney, you will not be in the case scenario of definitely working away.
Sure, you'll find a path forward. That's great. And you talked about the fees a little bit, so let's touch on that now. So who typically does cover the notary and property registration fees in Cuenca, the buyer or the seller?
The buyer. Let's list again all the expenses involved. We have legal expenses, which of course each party pays to the attorney involved. We have the property taxes that must be paid before the transaction is done. That it's paid by the seller because he is the owner of the property. And then we have, for the purchase itself, we have alcabala. This is paid by the buyer. Plusvalia, this is paid by the seller. And then we have notary fees, that it's typically always paid by the buyer. And we also have property registry fees, always paid by the buyer. Okay, so those are the fees that we have, and this is how they are paid.
So the due diligence side of things, that's obviously super important to get right. And so before you actually sign anything at the notary deed, like how can we verify that the property is free of liens, mortgages, or other hidden issues, and what sort of tools or resources do you recommend?
I always recommend to do what it's called a property record inspection or a property record search. Sometimes people will limit it only for the property registry. I recommend a full checkup in which we check at the municipality and we check at the property registry. At the municipality, we can get what it's called a ficha catastral. We can get an avalúo catastral too, and we can do a general research in the webpage of the municipality to find out if there are any debts or any pending processes at the municipality. Okay, this we can do online. Okay, but again, ficha catastral avalúo catastral, and then a research of pending values to be paid. And also you can do a research of pending administrative requests, in which using the clave catastral, you can see if the property is involved in any kind of legal process at the municipality. And then we have the property registry search, which allows you to know if there are any prohibitions, if there are any court cases going with this property, if there is ownership issues, inheritance processes, anything. You can find out at the property registry getting an historial de dominio or a certificado de gravámenes. I always recommend to do the full thing. You will have a little extra fees there, but it's definitely worth it. You know, it's the due diligence that you do not want to escape.
Peace of mind. I mean, that has a certain value for most buyers. And so I think for most people, it certainly makes sense.
Correct.
So moving on to, let's say, the resale side of things. So hypothetically, we have a party, they've gone through and they have gone to the notary deed and they've signed the paperwork, but something's happened in the registration office and it hasn't gone through properly. What happens then if that party then goes to resell that particular property?
If that happens, you have the right for something called resolución de contrato or contract resolution at the courthouse to sue for your money being refunded back to you.
So you'd have to go to the original seller?
Yeah.
You got it.
Exactly. You have to go to that party that sell the property to you and have that person at courthouse pursue so that they would refund you the money. There is a different option tool called cumplimiento de contrato or contract accomplishment. But if that happens, the other party, the party that bought the property within this issue going on, will lose the property, and that will probably cause the judge to put your case a little bit more complicated, but indeed it can happen. But in most of the cases, when that happens, my recommendation is to fight for contract resolution.
Sure, but if you're the buyer, for example, the secondary buyer of the resale, then my suggestion would be to walk away under that scenario until the original purchase is effectively sorted out.
Oh, if you're the second buyer, you mean?
Exactly.
Oh, absolutely. If you're the second, but sometimes the issue is that you have no way of knowing this, because the property registry will have no records of a deed that has not been inscribed, and the municipality won't have the records too. What you can get indeed, but this need, of course, to have a person that really knows what she or he is doing. You could go online to the municipality and search for all the payments that have been done during the year for a property. And if you see that alcabala and plusvalía have been paid, you can know then that there is very likely that a different sale happened and for some reason it hasn't get inscribed. But it's not a direct answer.
Sure.
You need their experience to link thoughts.
So it's a little bit of sleuthing to be like, you know what, this is probably what's going on.
Exactly. If you check and you see that for that property, alcabala and plusvalía were paid, you only pay those taxes when you are going to get a deed at the notary. At the same time, if you see that those taxes have been paid, but at the property registry, the owner is still the person that you're dealing with, you know for sure that a previous sale happened before and it hasn't get inscribed. If that is the case, walk away, because yes, one of the legal rare case scenarios, it's that even after you pay and have a registered deed, the previous buyer will sue your seller and get the judge to order the property to be given to him. And then you would have to sue your seller, and it's a nightmare. So
Sure. That's definitely best to walk away if you find that issue in time.
Exactly.
So moving on to inherited properties, are there any additional steps required for inherited properties just to ensure that they are properly registered? And are there any, common pitfalls that we should be looking out for?
If you are buying a property that came from inheritance, you need to make sure the property registry of two things. One, either that one of the beneficiaries bought the share of the other beneficiaries and now has total and complete ownership, and that person must be your seller, or you have to get the certifications at the property registry to find out where in the stage they are, and if they are in the stage where they have already done the posesión efectiva or the liquidación of the assets, then you can make sure that all the people that are listed in the property registry, number one, add up 100% of the property. in co-ownership, and number two, that all those people sign the deed at the notary, because you will need the signature of all of them if they still have co-ownership.
Yeah, that's good to know. So if there's family members involved, it's just a little bit more of a process. More people equals a little bit more difficult.
Correct. Not necessarily, because the steps are absolutely the same. You just need to read those property records very closely and make sure where in the transaction they are. Whether it's still under co-ownership or only one of the beneficiaries has become the total owner, and if it is co-ownership, you make sure everybody signs. Sure. So the steps are the same, but you need to stay a little longer on the last step of the property record, making sure you have everything right.
For me, it's just more complex, because getting a large family to agree on anything can be difficult.
From that point of view, yes.
Making sure that initial deal is, one, agreed to, and secondly, followed through from the legal steps.
Yeah.
There's always potential for one of the family members. Families are people, and people sometimes get upset or whatever. And
yeah, that's absolutely
blow
true.
The deal out of the water sometimes. So I think it's, from a legal point of view, completely, I think the steps, they're going to be the same, but just from a practical deal perspective, in my experience, it's just a lot more effort when we're dealing with multiple people.
I agree on that, but yes.
One person.
Yeah.
And so some errors or pitfalls. So what, in your experience, what are the top mistakes that can lead to registration denials, and how can buyers really try and avoid these ahead of time?
Get a good attorney. Yes, because basically the reasons why you get, as we explained and went over just a brief minute ago, the mistakes or the reasons why you get, especially the monster, the aclaratoria, can only be legal mistakes. A clause was included that shouldn't be included. The lawyer didn't make sure to attach all necessary documents. So the devolutivas, very hard to avoid them, because again, even if it's legally perfect, maybe the agent that you get at the property registry doesn't like that you use the word cost instead of price, this kind of things. But they are very easily solved. Yeah. But the real issue that you need to be concerned of, which is the aclaratoria, the only way to avoid it is to make sure that you get a good legal advice, to make sure that you have everything that needs to be on the agreement, and to not get what you should not have on the agreement. That's basically the only way you can.
Sure. I think for me, one of the cruxes of some of these issues that pop up is the process is still very manual. So basically you're relying on someone to get the document, go here, go there, go over there, get this stamp, get this little thing here. And so because we're introducing an element of human interaction every single time, there can be little mistakes that pop up. And so I think that's at least partly the reason why we have some of these devolutivas.
The little ones.
See, the little mistakes.
Yes.
And so moving on to the municipality side of things. So obviously we do need the taxes and approvals. Is there any circumstances, for example, where the municipality is going to deny the approval, and I guess how can we avoid those? Yes,
it can happen a lot, especially for something called error de cabida. For example, when the distribution, the square meters, the boundaries of the property that is contained on the previous deed doesn't match with the records of the municipality. They have a different square feet measure, or they have a difference on the boundaries. When this happens, you need to go through an error de cabida or a correction of linderos or boundaries. So those are majorly the reasons why the municipality will say no. The other option where the municipality will say no, it's when the minuta, it's not correctly written and it has mistakes. They would say, no, this is a mistake. We would not be getting the taxes for you. Now, in that case, it's really easy. You just provide a minuta with the right information and it's done. When we have those other things like the error de cabida, linderos, and so on, we do need to complete a different process at the municipality. And those, especially the error de cabida, can take some months to get resolved.
Got it.
Yes.
That's really good to know. And you said before that every canton basically has its own registration office. Mm-hmm. And so obviously we deal mostly with the Cuenca registration office, but Are there differences, interacting with, let's say, the Cuenca office versus another canton, I don't know, Resale or someone like that?
Yes. One of the major difference is, for example, the property registry here in Cuenca will not ask for the property records. That's why I mentioned it's not mandatory, but you better get it for due diligence. Some other property registries in Ecuador will ask to have that as an attachment. That is one of the major differences. Other difference is that on little cantons, sometimes the property registry and the commerce agency or the registro mercantil are within the same office, but that really doesn't affect your experience as a user. So I will say those two are one of the most common differences that you will encounter.
And coming back to, I mentioned the manual nature of the process. So my understanding is that the registration office in Cuenca is not really digitized. But I want your input on that in terms of how much of the process in the registration office itself is digitized, and does that have some sort of effect on, let's say, the transparency or just overall efficiency for the buyers?
It's a very mechanical process. Basically, we still have human beings that go over each page of your deed.
It's not digital, right? It's
no, all
paper.
Yeah, piece of paper. They write on it. They put their observations. They type it on. Everything. It's very manual. It absolutely. I think that's the major impact of why the law says 5 business days, but it can really take much more. So that's a major inconvenience. Now, the one good thing is that you will not waste much time going and checking if it's ready and losing your trip because it's not ready yet, because with the code that you get at the moment you enter your request for registration, you get a little code that you can go online and check where in the process your deed is.
Got it.
And once it has been finalized, you get a green warning, and then you know that if you go, you would have at least an answer. Now, getting this green thing doesn't mean that you already have it registered, because you can go there. It just means that the process of review has been finalized.
They have a decision for you.
They have a decision, either good or bad, either devolutiva or the monster. Yes.
Playing devil's advocate here, what happens if there's a fire in the property registration office? What happens to all those records?
Well, I'm sure this is really internal organization. I don't have the details. Sure. I'm sure they have some kind of, well, no, actually I do know. They do have the major information digitalized. That's why when you ask for the property records, you get a digitalized summary of the transactions and owners, literally since the property ever had existed, from moment one to the end of the story of that property. But the real substantial information, which are the deeds, they have that in scanned versions. Right. Actually, you turn in 2 copies and they give you 2 copies. So they have that on scanned versions. The process is still really manual, but the records are in the digital. So a fire will not affect anything.
Okay, cool.
Yeah.
That's good to know. Okay, moving on to the last question. If there was one piece of advice beyond using a reputable attorney when you're buying a property in Cuenca, what would that be?
It's honestly, especially for expats that are not really aware of the process, that is the key, because it's common not only that you have mistakes, but that you overpay things, that you are told that the tax is more than what it actually is. Those are really questionable things that do happen. But honestly, those little details, the other day I was talking to someone that told me that he felt that Ecuador law was like when you sign an insurance contract that has these little lines with many little things that you have to fulfill to get your refund. And that's exactly how property law is. So how will an expert be aware of all those little details? Honestly, it's really, really hard to be able to propose a different suggestion. One thing I could say is maybe talk to friends, see what their experience was on their own processes, so you can also see in advance if what you are being told by your legal advisor is true. And the other thing I would recommend is dealing with trustable real estate agents that can help you through the search of appropriate property.
Yeah, I would just add to that. I would definitely suggest getting some sort of second opinion if some sort of radar or some sort of spidey sense
Doesn't
starts to
sound
go
right.
off. Exactly. Trust your gut always. And also, if you're, let's say, using a real estate agent and they're recommending someone, be very careful under those different scenarios. If they're recommending some sort of attorney for whatever reason, then just be very clear on what is their relationship. Maybe their family, maybe whatever. But
Yeah.
There are scenarios where they kind of work in these little teams, and the ultimate outcome is really just to extract the maximum amount of money from you as a client that doesn't know any better.
I think one recommendation I can indeed give, and this is more than during the process, because again, how can you know these details of the law if not with an attorney? But do not ever, this is a real good advice. Sometimes you would hear, especially from Ecuadorian that you don't need an attorney, just go to the notary, give the paperwork, they will prepare a deed. Not a good idea. They will just use a generic form. They will not consider the specifics of your agreement. They will not take care of you understand what the heck you're signing or not. They don't speak English, and
the notary lawyer, for example, they're not necessarily looking after your
quality.
interests.
Exactly. They're just getting paperwork and filling out in generic forms. Doesn't mean they're bad people, doesn't mean they don't know what they're doing, but it's just not personalized. They don't really difference you from any other person walking in your particular transaction.
They're protecting the transaction.
Correct.
They're not protecting your interest in that transaction.
Correct. But something I can indeed say, which is not much advice of how to have a successful process, but how to prepare for the process, is watch videos like this. Read articles, inform yourself so you are not fooled by whatever person you go consult on. So you have a little bit of an idea and you can contrast what you are being told to what the previous knowledge that you have is. And in that way, you will not only be able to get the information that you need, but also you will be able to feel much more comfortable, and you will be able to rely much more in the process. So that is a due diligence that I do recommend doing.
Completely agree. Education is key, and that's why we do these videos. So if you're thinking about buying a property here in Cuenca or even Ecuador, you've got some more information in your arsenal that you can use, so you can maybe ask the right questions to whatever attorney you happen to use. What is the due diligence process? Things like that. Things that you may not necessarily think of before you actually watch a video like this, because you need to start somewhere, right? And so
correct.
That's what this has hopefully given you is a little bit of a start. So just quick recap. If you walk away with one thing today, let it be this. Never assume that a notary deed is enough. Without the property registration inscription, you're just not the legal owner, period.
Correct.
And a massive thank you, Sabrina, Candela, for unpacking these legal landmines. If you are buying property in Cuenca, do consider consulting a legal expert like her team at Expat Law Group. And hey, if you're feeling overwhelmed by the process, my team at YapaTree.com is here to help simplify it for you, from finding your perfect home to guiding you through deed signing and registration. We've got your back. And so do head to YapaTree.com to see our listings, or send me an email, jason@YapaTree.com. And a core part of our mission is to help you avoid horror real estate experiences like this one. Ciao, ciao.